Tatay Digong stood with Bangsamoro. Now Bangsamoro stands with
The
him.
International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Judge Motor. Good morning, everyone. I'd like to welcome everyone in and outside of the courtroom. Court officer, kindly call the case.
Madam President, Your Honors, situation in the Republic of the Philippines in the case of the Prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121, 0125, and for the record, we are in open session.
Judge Motok, thank you very much. I would like to ask the parties and participants to confirm that the team composition is the same as yesterday's. Good morning, Madam President, Your Honors. I can confirm that indeed the OTP is represented by the same staff members. There have been a few changes over the days, but they are all here. The presiding judge, thank you very much, Deputy Prosecutor. Ms. Masida, for the legal representatives of victims. Ms. Masida, good morning, Madam President, Your Honors. Same composition as yesterday. Finally, the defense, Mr. Kaufman.
Good morning, Your Honors. We remain the same.
Merci beaucoup.
Thank you very much. I would now like to call upon the defense to address the court and to complete their submissions on the merits. We have to add the time that the defense did not use, but you can use all your time. We will have a break at 10:30, and then we will continue in the afternoon. So, Mr. Kaufman, please proceed, and you must respect the Chamber's decision regarding redactions. Otherwise, I will be obliged to interrupt you each time so as to protect victims and witnesses. Mr. Kaufman, please go ahead.
I do indeed thank Your Honours for that consideration. And we did, in fact, have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate the redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterises as involving so-called high-value targets, the defence makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritization category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement, and in this sense, it is no different from a similar acronym in another country where I have clients. APOTS, or Australian Priority Organisation Targets. HVT is not a code for an instruction to kill or a witch hunt. It was a prioritization tool within anti-drug operations applied across regions and units on the basis of intelligence assessments, alleged position within drug networks, or inclusion on watch lists. Classification does not imply selection for murder, any more than it is proof of unlawful intent. The prosecution itself acknowledges the existence of formal operational frameworks, including police circulars and structured campaigns. Within those structures, individuals could be designated high value for purposes of operational attention. Many HVT operations, in fact, resulted in arrest or surrender, albeit some resulted in fatal encounters. For this reason, each alleged HVT incident must be scrutinized on its own evidentiary foundation. When the incidents falling under Count 2 are examined individually, the pattern we submit is similar to those incidents falling under Count 1. Namely, heavy reliance on insider testimony, wishful and selective reading of police reports, and dubious and tenuous linkage to Rodrigo Duterte. Now, the operations cited under Count 2 were conducted within the framework of the lawful war on drugs, and as such, operational contexts are consistent with planned law enforcement activity, including buy-bust operations and coordinated arrests, rather than preordained killings. The evidence for Count 2 incidents consistently shows that the deaths occurred during armed confrontations in which force was used in response to an imminent threat, in accordance with the rules of engagement repeatedly articulated by President Duterte, namely that lethal force was permissible only where life was in danger. Across the Count 2 incidents, there exist contemporaneous documents, whether it be arrest warrants, operational records, or firearms recovery reports, all of which reflect legitimate police operations that escalated into exchanges of gunfire. The general record does not substantiate a theory of wanton execution, yet the prosecution seeks to rely, once again, on the testimony of criminals spilling their hearts with a tacit understanding that they will never be prosecuted. In 4 of the 5 incidents, contemporaneous reports document the recovery of firearms at the scene, indicating that the weapons were used against police and prompting a responsive use of force. In incidents 12, 13, and 14, the operations were authorized by judicially issued search warrants. We have diagrams on the screen being shown. I'm not going to stop. They will be presented throughout my presentation continuously, all in an attempt to save time. Those circumstances are squarely within operational legality and fundamentally incompatible with a pre-planned murder. Incident 14 is particularly instructive. 4 individuals were arrested alive. To us, that demonstrates selective and not indiscriminate use of force. In incidents 10, 13, and 14, gunpowder residue was detected on the victim's hands. At a minimum, that forensic finding is consistent with an exchange of gunfire and not consistent with a straightforward execution narrative. And the prosecution and the victim's representatives simply can't have their cake and eat it. They can't say in one breath that drugs and guns were planted on victims and therefore dispute crime scene evidence, while at the same time complaining about the lack of crime scene evidence. Yet the prosecution virtually disregards these objective and forensic indicators in favor of narrow and often uncorroborated insider testimony. This is best illustrated in Incident 10, which rests almost entirely on P1160's assertion that a firearm was planted at the scene of the crime, and the official report fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely assumes that it must have happened, before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture. We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident. a forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony, which is notably, once again, uncorroborated. Incident 11. This is the sole incident in count 2 where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice while being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person present, on whom the prosecution relies for corroboration, did not hear the conversation. After all, would it not have been an item of interest to all those present in that specific location that the President of the Republic himself had condescended to discuss matters of such a criminal nature by way of telephone? So the ridiculous assertion stands solely on the word of one single individual. The only other corroborating witness, the one who heard nothing, acknowledged a personal resentment that he harbored for the then President, Rodrigo Duterte, for reasons you will find in PHL OTP 0001642-R01 at 0022, lines 695 to 708. Once again, I can't mention the reasons because it's redacted. Voice recognition in uncontrolled conditions, while being physically moved, and uncorroborated by any forensic or documentary evidence, cannot constitute substantial grounds for confirmation, particularly where it forms the sole mechanism for attribution. Incident 12. This incident relies heavily on a central witness whose credibility is seriously compromised by retaliatory motives he admits to harboring against Mr. Duterte. This can be found in OTP tab 55 at page 27. Line and another reason that we cannot mention in open session, but which can be found in PHL OTP 000-15167-R01 at page 0008. For this particular incident, the case record demonstrates that this operation was conducted pursuant to a judicially issued search warrant, with operational reports and documentation concerning the recovery of firearms. To display such an extensive contemporaneous record, one would expect the prosecution to produce forensic evidence capable of undermining the reliability of these materials, evidence demonstrating fabrication or inconsistency sufficient to reduce their probative value. None, however, has been forwarded, because none presumably exists. Incident 13. This relates to the killing of Mayor Espinosa, whose name I can mention, and Raul Yap, who was shot in a police cell. The prosecution's case is largely premised on a witness who claimed to have heard but admitted not to have seen anything. Thus, there is nothing in the prosecution's evidence to contradict the alternative theory proposed for this incident, which is that there was a firefight between the victims and the officers in the police station Leyte sub-provincial jail. Nor is there a need to enter into these conflicting accounts, because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender. And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald de la Rosa, commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, That is where the incident ended, despite Mr. Jeremy exhorting us to believe otherwise. What happened thereafter, as awful as it may be, had nothing to do with our client, and not one witness can say that. The prosecution's narrative in Incident 14, the raid on the house of another person who I can mention, the mayor of Ozmiz City, rests exclusively on a witness who, for reasons we cannot explain in open session, is wholly unable to provide complete or reliable testimony for reasons that can be found in D36, tab 181, lines 128 to 155, and lines 191 to 212. Contemporaneous documentary police reports reflect that this police operation proceeded pursuant to 6 judicial search warrants, something hardly consistent with a premeditated murder scheme. After all, if the intention was cold-blooded murder, why go to the bother of involving a judge? Official investigative materials also indicate that officers approached the premises, announced the execution of the warrant, and were met with gunfire that struck a patrol vehicle and injured an officer, prompting a return of fire. This directly refutes what Ms. Massiter so categorically claimed on Tuesday, namely that none of the arresting officers were ever harmed during the operations. Transcript. T5, page 44, line 24. In every case, the victim was killed, and none of the arresting officers were harmed. The exchange of fire, as reported, is supported by the fact that gunpowder residue was found on 7 individuals, including on the mayor himself, and a paraffin test turned out positive on the person of one of the victims, indicating that he had discharged a firearm, something totally negating the gun plant theory proposed by the prosecution's only witness. It is also worth stressing that 4 individuals were arrested alive following the operation, and that one of them was subsequently sentenced to life imprisonment after the domestic courts rejected claims of evidence planting. That fact alone is not consistent with a theory of indiscriminate execution, but is rather consistent instead with arrest and prosecution within the boundaries of the law and not indiscriminate use of force. So to summarize, across incidents 10 to 14, count 2, we see absolutely no evidence whatsoever of any attribution to Mr. Duterte on the granular level, nor do we see any evidence of a mutually agreed course of conduct on the upper hierarchical level of government involving Mr. Duterte and his alleged so-called co-perpetrators. The record reflects police operations conducted at unit level, sometimes under judicial warrant. P1166 describes operational discretion resting with the local team leaders and characterizes planned killings as rare and locally motivated. P1066 clarifies that to neutralize, that word which has been heard so often in the last few days, neutralize referred to lawful enforcement, not killing, the prosecution's own witness. The Senate committee report refers to rogue uniformed police. To conclude, the evidence reflects decentralization, not control required under indirect co-perpetration. And for these reasons, confirmation on count 2 cannot stand. Now, I'm going to start count 3. We have until 10:30. I'm conscious of the time allotted to me. So count 3 relates to the Barangay clearance operations during the presidential period. Incident 15 marks the beginning of the Barangay clearance operations. Now, from this point forward, a familiar pattern emerges in the prosecution's narrative. The same modus operandi, to employ Mr. Jeremy's language, routine buy-bust operations are recast as sham exercises designed to conceal extrajudicial killings allegedly ordered from some unspecified source from above. Mr. Jeremy claims a target was identified through the use of lists. Well, there's nothing wrong with that. As one witness, an intelligence officer, explains in his testimony, the use of lists is a normal standard procedure. Once validation was conducted on a person, X, a file on that person would be created as a result of intelligence operations. Then, so claim Mr. Jeremy and Ms. Croft, the target is murdered and reports are falsified and rewards are paid out. This, Ms. Croft suggested at transcript 5, page 23, lines 11 to 13, is the systemicity of the pre-planned attack. But this is not the case. The defense can point to contemporaneous official records generated across different units or organizations that show clearly that in the majority of these incidents, the evidence reflects legitimate law enforcement operations involving spontaneous and reported exchanges of fire and uses of force subjected to forensic and administrative review. These are not clandestine acts hidden from scrutiny, Madam President, but rather recorded operations consistent with self-defense in the course of policing. And where the evidentiary record supports competing inferences, including the inference of a lawful armed confrontation and the inference of an unlawful execution, well, and with this I will conclude, in dubio pro reo. 10:30.
Merci beaucoup.
Thank you very much, Mr. Kaufman. So I've understood that you would like to use the time that remains to you, and you still have 20 minutes, actually. I understood that you wanted to use that time. Yes, I would, but I'm not so sure if I can conclude in 20 minutes.
C'est possible. OK. Nous essaierons, madame.
Ouais, donc vous avez la...
Judge Motek, very well. It's still you. You have the floor. Proceed.
Across incidents 15 through 49, the Chamber will repeatedly encounter contemporaneous buy-bust or warrant-based documentation, reported exchanges of fire, gunshot residue findings, ballistic testing, immediate hospital transport, internal investigations, and in some cases, prosecution and conviction of officers. Against all of this evidence that you've just seen on the screen here, the prosecution offers single insider accounts of alleged stagings, uncorroborated assertions of weapons planting, and nanlabans, unsupported by any forensic evidence, often speculative, frequently contradicted by the alleged co-participants, or yet, more often, complete silence from the alleged co-participants, as they were never even questioned about the incident. And most importantly, despite Mr. Jeremy's assertions on Tuesday, wherein he claimed that the police reports were repeatedly falsified to legitimate the operations as acts of self-defense, copy-paste reports in which victims were frequently blamed for their own deaths, there is zero proof, none, that the only existing contemporaneous documentary evidence is fabricated or unreliable. No proof whatsoever of this supposed falsification in the entire case record. And on this point, let us just clarify a basic principle, that a state document with the appropriate stamps and signatures and what have you is prima facie reliable, or in other words, it carries a presumption of administrative regularity. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption. Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome this presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified. Now, we do not deny that in some instances the record may reveal unlawful conduct by individual officers. Mr. Jeremy referred to a press release, OTP tab 108, in which the police proclaimed that 32 people were killed in Bulacan big-time operations, and then went on to refer to this as one single operation in which 32 victims were killed by the police in Bulacan. But what Mr. Jeremy failed to tell you, Your Honours, is that one of the prosecution's own witnesses explained clearly that he investigated these deaths in an official capacity soon after the killings and found that 33 people were actually killed in different municipalities and provinces in central Luzon, but that their bodies were delivered to Bulacan. This was not, as Mr. Jeremy suggested, a single incident of mass murder, but rather an improper aggregate of a series of law enforcement operations over the course of 24 hours executed in large geographical area and for which we have no evidence in the case record. There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations. And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen. Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally. However, another witness, working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial killings disguised as lawful operations, and confirms that there were no standing orders to kill. The operational objective, he explains, was arrest. Lethal force only when the circumstances required it. And you can find this information in Defense tab 96. And we see this pattern again and again and again. In Incident 40, for example, P1131, who worked with the individual alleged to have shot the suspect, stated clearly that the killings occurred only in circumstances of lawful use of self-defense. That can be found at Defense tab 74, and you can see it on the screen as well. This type of testimonial evidence is also corroborated by documentary and forensic evidence. Incident 15, the prosecution again resorts to its usual pro forma narrative of stage killings or nanlabans. But what it has not done, of course, is prove this. Whereas I urge Your Honours to look at the screen, where you can see detailed documentary evidence about how this incident came about, and I summarize: a spontaneous exchange of fire after the suspect discharged a firearm, ballistics testing of the officer's weapon, affidavits by the police officers involved, and formal review and investigation of the officer who fired his weapon. Now, I'm not going to sit here and bore you with all the evidence we have on every single one of these incidents, But what I will tell you, Your Honours, is that we have this type of forensic evidence proving attempts, arrests, armed resistance, and responsive and sometimes disciplined use of force in no less than 13 incidents. I don't know where Mr. Butoyan got the idea from that there's no forensic evidence left in the case record. And may we remind you, Your Honours, until the prosecution proves otherwise, which it has not, these state documents remain prima facie, authentic, and reliable. For incidents substantiated by a single witness narrative and unconfirmed by alleged co-participants, I refer Your Honours to no less than 9 incidents. One prosecution witness, P1160, is the sole testimonial evidence for at least 3 incidents, while another 6 incidents are premised entirely on the testimony of P3. Now, what's interesting about these incidents is that P3 alleged that he was only one of a group of 3 or 4 perpetrators, and these other perpetrators are actually also prosecution witnesses. Yet none of the other witnesses corroborated his version of events. Not one. A couple of incidents alleged by the prosecution appear on its own evidence to be unrelated to drug enforcement, and thus questionably part of the fantasy common plan or organizational policy. For this, I would refer you to incidents 31 and 41, which involved targeting of 2 individuals, again, because of non-drugs related conduct. I'm not sure whether I can mention the type of conduct without revealing the identity, so I shall refrain from doing so. The prosecution has not presented any evidence to substantiate any nexus to anti-drug operations in either of these incidents. And for this, I refer you to D36, tab 158, at page 4. On the perpetrator's own account, the trigger for the killing was a personal grievance relating to property damage. There are numerous incidents against unidentified or improperly identified victims. The victim in incident 45 is described as a minor, just as in incident 38, another incident on which Mr. Jeremy focused on Tuesday. And by the way, on the subject of the killing of children, of course it ticks the right boxes for the prosecution insofar as it pulls the heartstrings. But apart from Kian de los Santos, the prosecution has not, despite its emphasis on children, presented to this chamber during these proceedings any evidence that even one victim, apart from Kian, in its 49 incidents was a minor. No birth certificates, no corroborative evidence, nothing. While incidents presented as involving minors are indeed grave, Article 61 requires proof, not emotion. It is for the prosecution to prove that the children were involved in these incidents, and not for the defense, once again, to prove a negative. Now, this evidentiary deficit extends even further. The Bulacan Provincial Office provided a certificate indicating that it had no record corresponding to the names of the victims, whose names have been redacted on the slide, which we will show you. Okay, well, we'll pass on. But their names have been redacted. And these are alleged police killings, yet no operational report. Indeed, no contemporaneous documentation whatsoever has been produced. So on what does the prosecution base its claim that these individuals were murdered by the police other than P3? The prosecution relies almost exclusively on the account of P3 echoed by P8. And this is rather ironic. Does the prosecutor claim that P3 is corroborated by P8 when the source of P8's information is in fact P3 himself? Bootstrapping logic, once again. The alleged direct perpetrator, P1201, stated during his interview that he had never participated in an operation involving a child. The other officer allegedly present during both incidents, P1131, was never questioned about these events by the prosecution. And that omission, we submit, is not neutral. These incidents, therefore, cannot simultaneously be characterized as manifestations of a centrally designed OTBT-based common plan, because they quite clearly fall outside of that plan. And it does not reflect what the prosecution on Tuesday described as the systematic features of a national network operation. Instead, according to P3, the motive was personal financial gain through the sale of bodies. And if P3's account is accepted, it reflects opportunistic actions for personal gain of the most macabre kind. As held in Al-Hassan, an opportunistic act committed for personal profit without more falls outside the common plan. Now, just to finish up quickly on the issue of identity, in Incident 43, even the alleged perpetrators are not identified. Without identification, the Chamber cannot assess their institutional affiliation, chain of command, or attempt to make any possible linkage to Mr. Duterte. One more thing, Your Honours. The prosecution focused for some time on Incident 23. I can mention his name, Mr. Benjamin Vizda. Mr. Jeremy displayed compelling footage of Mr. Vizda's arrest and what happened when Mr. Vizda was taken away on the motorcycle. The fact that while handcuffed, he attempted to grab the gun of one of the policemen, leading to a struggle and prompting the motorbike to fall over and the policeman to shoot Mr. Vizda twice in self-defense. And that this PNP report appears to be corroborated by another prosecution witness, whose testimony fully aligns with the substance of the police document. Mr. Jeremy claimed that the PNP reports were false, relying solely on the allegation of one witness that the scene was staged. This witness claimed that the handcuffs were removed from the victim, that the body was loaded on the tricycle a few minutes after being shot and then brought to the hospital. However, his account is contradicted by the very picture the prosecution has shown you on Tuesday. Indeed, it appears that the prosecution is submitting documentary evidence which undermines its own witness's testimony. As you can see here, handcuffs are on. The body is on the ground rather than on the tricycle. Photojournalists are also present. This contradiction was even noted by the prosecution's investigators at the time of the interview and was put to the witness. And when confronted by the investigators, what did that witness say? I don't know if I could. The prosecution must still establish vertical linkage to Mr. Duterte. Or has the prosecution, 2 minutes left, not be satisfied? And finally, with regard to count 3, the prosecution's witnesses themselves concede that there was no formal approval process. Targets were selected without validation, officers acted for personal reasons, and decisions were taken locally. All of this destroys the assertion that there was a mutually agreed common plan. I will elaborate. P1160 claims hierarchical transmission of policy within the police, while simultaneously acknowledging officers' autonomous killings for personal motives. Those propositions cannot comfortably coexist. P3 explains that certain officers acted outside any common plan and for opportunistic reasons. See Incident 38. In Incident 49, P1207 attributes instructions to local officers without evidence of communication or direction from higher authorities. And most significantly, P1207 P1207 states after a certain death, once again abiding by the redactions, Tokhang operations and killings ceased. This indicates, Madam President, Your Honours, that dependence on specific individuals, not an enduring organizational policy. A system-wide common plan cannot depend on the continued presence of a non-fungible local official. And with this, I conclude.
Judge Motok, thank you very much, Mr. Kaufman. All the arguments on the merits have been heard. We will now break for 40 minutes up to 10:30. And after we return, we will continue with the closing arguments or submissions, starting with the OTP. Thank you very much. Court is suspended.
Crime if a search warrant is issued, that Mr. Duterte, as we made clear in our presentation, moved co-perpetrators from Davao to Manila and appointed them to high positions. So when he appoints the chief of police, and part of the chief of police's job is to kill thousands of people, it's not a surprise that the police reports don't reflect that. If they decide to murder Mr. Espinosa and Mr. Yap while they're held in jail, it's not surprised that that can be done when Mr. Duterte appoints the head of the Department of Justice. Similar, he talked about, again, I'll get to it, talked about neutralize, and how that is a neutral word and needs to be taken in context. I'll come to that a little bit later. But again, there's evidence in this case, some of which Mr. Jeremy went through in his presentation, that neutralize meant to kill. Whether he is correct, or we are, whether we're able to prove it beyond reasonable doubt is another issue. Whether we're at substantial grounds is clear. We are. And I just say, again, responding to his argument about the documentation, that it's not unique to this case. In war crimes trials, crimes against humanity trials, where the very top leadership are the persons on trial, and when they're committing their crimes, they don't put it in writing often, let's go out and commit a crime. Mr. Kaufman will know this because we both worked together at the ICTY. During the trials for Srebrenica and the other Bosnian Serb army crimes, the VRS, every single order that turned out to be criminal, virtually every single order, had in the order from the General Mladic down the chain, respect the Geneva Conventions, treat prisoners of war properly, treat civilians properly in accord with the Geneva Conventions. That was in virtually every order, and it didn't mean anything. It was boilerplate as part of their cover-up. I'll move on to some of his points from yesterday now. He spoke at length in the beginning about Article 7.1 and an alleged problem or inconsistency with the all-history case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the El History case, which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in El History did not concern the definition of the civilian population. It was about the nexus requirement, under Article 7, and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population. It was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte. Very quickly, he complained or spoke about well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even 2 of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade Your Honors to take the view that neutralize didn't mean anything nefarious, quoted a statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So he's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10. In the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. Does not. As I said, this is the lawyer, Duterte, trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honor should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7, he said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify, and for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights, and they do not grant immunity. It just means a statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid, they shouldn't be interviewed, that's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for. His killings of his own people, the Filipino people. We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents. Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my cite because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it. I'm going to play more of it now, about 2.5 minutes.
Na ginawa ko man ang lahat sa panahon ko para may konting katahimikan at mapayapa ang buhay ng Pilipino. Ang problema nito, ewan ko kung ang tingin ng ako'y raw yung o ganito na lang. Ito ganito na lang. O sabi ko, assuming na totoo, totoo talaga yung naririnig ninyo. Bakit ko ginawa yan? Para sa sarili ko? Para sa pamilya ko? Para sa inyo at ang inyong mga anak sa ating bayan. Ang higiin ko na lang sa inyo, total, kung ganito man talaga ang swerte ko sa buhay, okay lang, tatanggapin ko yan. Eh, wala tayong magawa.
Excuse me, counsel, you have 5 minutes left.
Hulihin tayo kung ikulong tayo. Kaya lang, meantime, mag-contribute kayo, baski $5, $10, para paglabas ko sa presuhan, paggawaan ninyo akong monumento katabi ni Rizal. Si Rizal may hawak na libro eh. Akin.
Okay, what did we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote. He says, assuming that all the talk you hear is true, assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud, because he knows he's on video, he doesn't want the words there, assuming I'm the one who killed all these people. So he makes a little motion, crowd goes wild, and he smiles, because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family, but for the Filipino people, and it's obvious what he's talking about. He's talking about the murders. Again, the ends justify the means. Again, for him, the murders are a necessary evil for the greater good, as we heard right at the beginning of his career when he's teaching police officers to plant evidence. At the end of that video, what does he ask for? He says, I might go to jail, what can we do? But when I get out, contribute money so there can be a monument erected of him when he's released from jail. And he describes what he wants that monument to be to himself, former President Duterte. A statue, not holding a book like the national hero Jose Rizal, but holding a gun. 3 days before his transfer to The Hague, this old man, you could see it still up there. What does he want to be remembered as? The man with the gun. And he's just taken credit for killing his own people. It's time for him to take responsibility for these crimes he brags about and glories in. Can we go to the next one quickly? I think I got about 3 minutes. James. This is tab 146.2. It's a quote from a speech on August 16th, 2017. What did he say? Quote, I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead. End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it, justice demands it, and for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors. Thank you.
Merci beaucoup, Monsieur
Thank you very much, Mr. Nichols. We will now go to the closing statements of the common legal representatives of victims. You have up to 12:30. Maître Andres will present the closing statements. George Motok, you have the floor. Mr. Andres.
Madam President, Your Honors, good noon. In our closing statement, the common legal representative for victims will first rebut the defense submissions. Then we will provide the larger context why the confirmation of the charges against Mr. Rodrigo Roa Duterte is vital for the victims, especially in relation to their communities and the Filipino nation. Your Honors, listening to the defense submissions on the merits yesterday and today was to me like listening to the parable of the elephant, wherein they want us to see only the parts of the elephant: the trunk, the tusk, the ears, the head, but not the whole of the elephant. We must look at the whole context. Madam President and Your Honors, it's also my duty as the common legal representative for victims to express the views and concerns of the victims. As they're watching these proceedings, they have stated, and when they heard the defense effectively submitting, that the chamber should ignore the systematicity and the widespread nature of the attack. It's like their murdered loved ones are being murdered again. Having conveyed that as my duty, we will address the defense submissions in seriatim with 10 rebuttals. First, on Mr. Rodrigo Duterte's speech. Defense argued yesterday that, and I quote, relying on the former president's speeches as a means of proving criminal intent is impossible. I am quoting the transcript of yesterday at page 4, lines 5 to 6. But the victims convey that the Philippine context is vital in knowing and understanding the criminal intent and impact of Mr. Duterte's speeches. Under the Philippine Constitution, the executive power shall be vested in the President of the Philippines. Whatever the President publicly states is policy. And in the Philippine cultural context, when there is strong respect for those in government positions, especially the President, as head of state and as head of government, the words of the President is to be obeyed, no matter what. Especially for Mr. Duterte. He has portrayed himself as a man of his word. The defense even emphasized, and the prosecution also referred to this, last Monday that, and I quote the defense, for President Rudy, his word was his word, and the people knew it. End of quote. And that's the transcript of Monday, page 30, lines 18 to 19. The defense even stated that, and I quote, Rodrigo Duterte was and will always remain a unique phenomenon. End of quote. Referring to the transcript last Monday at page 30, line 14. Mr. Duterte was and is indeed a unique phenomenon in the public and vulgar way in which he uses words to dehumanize the victims of his anti-drug campaign, to excuse their murder, to shape the Filipino psyche to his murderous rhetoric, and to predispose the government agencies under his presidency to follow his words as presidential policy and as orders. And the records show that every time Mr. Duterte exhorts the killing, the murders of alleged drug users, people are murdered all over the Philippines. To our second rebuttal, we rebut the defense legal theory in its Thursday submissions vis-a-vis count 1, which contains 9 incidents of murder during the mayoral period of the suspect. The defense argues concerning count 1 that this is allegedly, and I quote, hardly widespread. And I'm quoting the transcript of 26 February 2026 at page 6, line 23. We strongly disagree. Widespread refers to the scale of the attack. Courts and commentators interpret it through several indicators, such as the large number of victims, the killings, the deportations, rapes, or other acts affecting many people. Geographical spread, wherein the violence occurs across multiple towns, regions, or a broad area. The long duration, the sustained attacks over time, rather than isolated incidents. The mass impact on the civilian population. The attack affects the population as a whole, not just a few individuals. The focus is on the quantitative magnitude. The attack is large in scope or effect. Systematic, on the other hand, refers to the organized nature of the attack. It is about how the violence is carried out, where there is pattern or methodical plan, repeated similar acts showing coordination, organizational policy or approval, wherein there's the involvement of the state or organizational structures, use of resources, logistics, weapons, or personnel deployed in an organized way. Regularity in pattern, not random or spontaneous, but structured. This is a qualitative criterion. The attack is carried out according to a plan, policy, or organized pattern. In the Nataganda case, the trial chamber has held in 2019 that, and I quote, the assessment of whether the attack is widespread is neither exclusively quantitative nor geographical, but must be carried out on the basis of all the relevant facts of the case. End of quote. In fact, in Nataganda, the trial chamber once again emphasized that, and I quote, the term systematic reflects the organized nature of the acts of violence and the improbability of their random occurrence. It refers to the existence of patterns of crimes evidenced by non-accidental repetition of similar conduct on a regular basis. End of quote. In reviewing the evidence in the record of this case, the only reasonable conclusion is that the attack against the specific group within the civilian population, individuals perceived as linked to drug crimes, was widespread and systematic. Contrary to the statistics shown by the defense, there is ample evidence about the high number of murders in this case. Third, on the death rate. Based on the 2019 trial chamber judgment on Ataganda, there is no requisite death rate in order to prove crimes against humanity for murder. Fourth, we rebut the defense legal theory in its Thursday submissions, which refer to the chapeau elements of Article 7 of the statute. The defense argues, inter alia, that allegedly, and I quote, this policy did not and could not constitute an attack directed against a clearly definable civilian population. End of quote. And I'm referring to the transcript of yesterday at page 10, lines 16 to 17. We disagree. Since the chapeau elements of Article 7 of the statute provides for, and I quote, widespread or systematic attack directed against any civilian population. End of quote. As the element of crimes provide, and I quote, attack directed against a civilian population in this context, elements is understood to mean a course of conduct involving the multiple commission of acts referred to in Article 7, Paragraph 1 of the statute against any civilian population, pursuant to or in furtherance of a state or organizational policy to commit such attack. End of quote. It is also essential to note that on the targeting of a specific category of civilian population, the pretrial chamber has held in the situation in the Republic of Kenya that, and I quote, the chamber takes into account the information relevant to the status of the victims, their ethnic or political affiliation, as well as the methods used during the attacks. End of quote. The same pretrial chamber in the situation in the Republic of Kenya further held that, and I quote, the issue of whether an act was committed as part of a widespread or systematic attack needs to be analyzed on a case-by-case basis with regard to each particular act. End of quote. Applying this legal principle to the case at hand, we have argued that the evidence on the record unequivocally shows individuals targeted by Mr. Duterte's anti-drug campaign overwhelmingly came from impoverished communities where social mobility is limited and opportunities are scarce. The same type of people in the same type of communities using the same modus operandi were targeted by Mr. Duterte's anti-drug campaign. People from the vulnerable communities, the poor and marginalized, especially in urban, informal settlements marked by high levels of poverty. Thus, we have shown last Tuesday, Your Honors, that Mr. Duterte's anti-drug campaign was really a war against the poor. Consequently, the document containing the charges was not, and I quote, muddled, end of quote, as argued by the defense in the transcript of yesterday at page 8, line 8. Rather, consistent with the chapeau element under Article 7 of the statute, the DCC in paragraph 17 refers to the, and I quote, widespread and systematic attack against the civilian population in the Philippines, end of quote, referring to paragraph 17 in the DCC. while the DCC in paragraph 20 specifies that this attack was against, and I quote, alleged criminals in the Philippines who were perceived or alleged to be involved in drug-related, including production, sale, and use, and other crimes such as theft and murder, end of quote, referring to paragraph 20 of the DCC. The latter, in paragraph 20, is merely a subset of the former in paragraph 17 of the DCC. Again, this framing in paragraph 20 of the DCC is synonymous with the framing in the situation in the Republic of Kenya, wherein police violence targeted perceived gang members. Fifth, the defense yesterday referred to Philippine Supreme Court issuances. And I quote, the defense inter alia referred to, and I quote, Supreme Court of the Philippines in petitions challenging aspects of the anti-drug campaign, end of quote. Referring to transcript of yesterday at page 26, lines 10 to 11. Madam President, Your Honors, I and Attorney Buturian are familiar with these petitions referred to by the defense because we were actually the petitioners' counsels in those petitions, and we actually argued before the Philippine Supreme Court last 2017 on this issue. Nevertheless, the defense critiqued the prosecution's manner of using the quote, Duterte's administration's year-end report for 2017, referring to PHL OTP 0003-3355 or tab 139 for the defense. Specifically, the defense argued that vis-a-vis the, and I quote, deaths of 3,967 drug personalities, end of quote, that, and I quote, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, end of quote. And I'm referring to the transcript of yesterday at page 32, line 1. Nevertheless, Your Honor, the same Supreme Court decision or resolutions referenced by the defense has stated with respect to those 3,967 drug personalities who died in the anti-drug operations from July 1, 2016 to November 2017, as indicative of the state policy of extrajudicial killings under the Duterte administration. As held by the Philippine Supreme Court in its notice of resolution dated April 3, 2018, which is PHL-OTP-003-3058, and which is tab 112 for the defense at pages 46. I quote the Philippine Supreme Court. Aside from the OSG's submissions in the present cases, we take judicial notice of the Duterte administration's 2017 year-end report, where deaths in cases related to illegal drugs and the internal cleansing conducted within the Philippine National Police are touted as accomplishments. And Your Honor, the next sentence is emphasized in the original resolution. The government's inclusion of these deaths among its other accomplishments may lead to the inference that these are state-sponsored killings. In the section Fighting Illegal Drugs and subsection Real Numbers, we find the following figures. And Your Honor, I will just quote the one that was in emphasis in the resolution. 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, as well as 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. 6. The defense referenced, again, the same Philippine Supreme Court resolution. But that same resolution held that nothing else to substantiate the OSG's claim of legitimate police operations. And I quote that specific portion in the Philippine Supreme Court's Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at page 47. The Supreme Court held that, and I quote, apart from these numbers and their bare allegations, there is nothing else to substantiate the OSG's claim of legitimate police operations. The lack of any submission of the required information and documents leads this court to believe that there is no basis to the OSG's claim. It is Hornbook doctrine that bare allegations unsubstantiated by evidence are not equivalent to proof, i.e., mere allegations are not evidence. End of quote. 7th, Your Honor. Again, in reference to the same Supreme Court resolution referenced by the defense, the Supreme Court also held there that the PNP cannot claim presumption of regularity on deaths occurring during police operations. Your Honor, I will quote that specific portion of the Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at pages 47 to 48. The Supreme Court held, and I quote, the PNP cannot claim the presumption of regularity in official functions because deaths are not supposed to occur during any of their operations. The presumption of regularity in the performance of official duty must be seen in the context of an existing rule of law or statute authorizing the performance of an act or duty or prescribing a procedure in the performance thereof. The presumption also cannot prevail over positive averments concerning violation of the constitutional rights of the accused. And Your Honor, in the next paragraph, all of it is being emphasized in the original. And I quote the emphasized portions. The Duterte administration's 2017 year-end report states that there were 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, and 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. This is a total of 20,322 deaths during the Duterte administration's anti-drug war from July 1, 2016 to November 2017, or an average of 39.46 deaths every day. This court wants to know why so many deaths happened, as expressly reported under the section Fighting Illegal Drugs of the Duterte administration's 2017 year-end report. Next, Your Honor. The Philippine Constitution provides for the right of life in Article 3. Therefore, because of that right to life, there is actually no presumption of regularity if a person is killed during a police operation. And actually, the presumption is reversed. It's actually the onus probandi on the police to prove that his or her actions were within the lawful requisites of self-defense. In fact, Rule 15.4 of the 2013 revised PNP operational procedures mandates the proprio motu investigations if death occurs during a police operation. However, Your Honors, despite the at least 3,967 deaths under anti-drug operations, there was no proprio motu investigations for all of these deaths. 8, Your Honor. The defense yesterday referred to the Philippine National Police Operational Procedural Manual issued in 2021. But the same was irrelevant and a non sequitur with respect to how the PNP construed and applied the word neutralize under CMC 16-2016 from July 1, 2016 until March 16, 2019, which is within the temporal jurisdiction of the court. The defense recognizes that the same Philippine National Police Operation Procedural Manual was published in 2021, specifically in September 2021. And it was already after the temporal jurisdiction of this court. Hence, it's irrelevant with respect to this case. 9th, the defense asserted that purportedly the Duterte's administration is, and I quote, intolerant for rotten apple police officers, end of quote. That's in the transcript of yesterday at page 32, line 20 to 21. This is not true, Your Honors. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for the government-recognized deaths of at least 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. In fact, the undisputed fact in this case is that the Philippines only investigated at most...
Excuse me, counsel. You have 5 minutes left.
At most 302 cases. And I refer to the February 27, January 26, 2023 decision of this chamber on the authorization pursuant to Article 18, Paragraph 2 of the statute to resume the investigation. The court here, the chamber has held, the chamber observes that at the time of the prosecution's request, the DOJ panel had referred to the NBI for investigation in case build-up 302 cases consisting of 52 PNP IAS cases, the non-laban cases, and 250 NPS cases. And in paragraph 39, from the information before the chamber, it therefore appears that the DOJ panel review does not amount to relevant investigations within the meaning of Articles 17 and 18 of the statute. Moreover, the number of cases reviewed by the DOJ panel, namely 302, is very low when compared with the estimated number of killings that allegedly occurred in the context of war on drugs operations. Res ipsa loquitur. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for these deaths. Last, Your Honor. The defense erred when it conflated Ms. Paulina Macida's statement that Rodrigo Duterte failed to prevent or punish with the theory that the prosecution has not charged command responsibility under Article 28. Ms. Macida's comment on the fact that Mr. Duterte did not take steps to investigate and prosecute was pronounced in the context of her submissions on the fact that encouragement of killings through public statements by Mr. Duterte sent a clear message that those responsible need not fear accountability and can act with impunity. Said comment cannot be extrapolated from that context, as the defense did yesterday. We do not suggest that Mr. Duterte should be liable under Article 28 of the statute. We maintain that there is ample evidence for confirming the mode of liability under Article 25(3)(a) as pleaded by the prosecution. Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice. Because in the end, Your Honors, the victims, they're also created in the image of God, and they also believe that the God of the universe is the God of justice. Madam President, Your Honors, thank you for your kind attention. This ends the presentation, the closing statement of the common legal representative for victims. May it please the chamber.
Judge Motok. Thank you very much, Mr. Andres. We will now take our break and resume with the final submissions of the defense at 1400 hours. The hearing is suspended. Judge Motok. Good afternoon, everyone, once again. Mr. Kaufman, you have the floor for 30 minutes for your final submissions. Please proceed.
Thank you, Madam President. Thank you, Your Honours. I don't propose to present a long rebuttal. The defence has made its submissions comprehensively, and it stands by everything that it has said and presented. I am, however, forced to respond just to a couple of the most egregious observations made by the learned prosecutor and the learned victim's representative. I will start with Mr. Nichols, the prosecutor, who tried to convince you that I had admitted that you cannot trust anything coming out of Mr. Duterte's mouth. Well, he took it completely out of context, didn't he? What I was saying, and what everybody understood, is that Mr. Duterte's speeches alone are totally insufficient to substantiate the charges against him. And the learned prosecutor apparently agrees. He said, throw them all out for the purpose of the confirmation. Even without the speeches, we have enough to confirm the charges. And then he celebrated the fact that he had managed to find one, and I stress, just one, example of a direct order, so he thought, to kill emanating from Mr. Duterte, and that is to be found in Incident 1. So, for the benefit of the record, let me just clarify and repeat what I said, and I refer you to transcript 4, page 65, at line 14 onwards, and I quote, P26, who, redacted, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told it was the mayor on the phone. Hyphen pure hearsay. That's what I said during the hearing. And I stand by my word. But because I thought that maybe Mr. Nichols might have caught me out, I went back to the transcript and the record, and I looked long and hard, and once again I quote P26's words from the evidence. I asked who called, and the redacted third party said, Superman. And to make things clear, the prosecutor's investigator then asked P26, was the person who took the call? Was it the redacted third party? And the answer he received was yes. So I repeat my submission with even more emphasis. Pure, unadulterated, and undiluted hearsay. What Mr. Nichols' rebuttal boils down to, maybe he didn't mean to infer it, but he did, all it boils down to is a plea that, well, Kaufman's pointed out a few problems, let's just leave it for the trial judges to sort out. And for that, he's quite happy to let Mr. Duterte fester in detention for years to come. In the United States, they call that kicking the can down the road. And as for the learned victims representative, I've been restrained up until now. I have paid my respect to the families of those who have lost loved ones, and I repeat that expression of sympathy that I made as my very first statement on behalf of the defense. But I would like to remind the learned representative for the victims that he is not a mini prosecutor, and to regale the pre-trial chamber with unsupported allegations that many, many children lost their lives is utterly inappropriate. His stance and that of his colleague have reflected the media reporting of this case, namely complete disregard of the evidence, and to be frank, you haven't heard one single piece of evidence cited by them. That's why they have Ms. Massiter sitting next to them. Indeed, the media interest in this case has been intense, but it has followed a familiar theme. Rodrigo Duterte is finally behind bars where he belongs. And as a defense lawyer, I stand up and I talk about due process, fair trial rights, and the presumption of innocence. But what use is that when the whole world has already tried and convicted him, and furthermore, make emotional arguments to justify their position? What about the presumption of innocence? Mr. Butuyan talks about threats emanating from mini Dutertes. He says that people are threatened by Duterte clones in countries all around the world. He tells you about Rodrigo Duterte converting millions of peace-loving citizens into bloodthirsty disciples. Not dozens, not hundreds, but millions, so Mr. Butuyan says. What an insult to the Filipino nation. And Mr. Butuyan concludes by presenting an emotional ultimatum. Confirm or Duterte will be portrayed as the person who vanquished the ICC. Those were his words. These submissions were quite unique for this court, and of course, totally irrelevant for the purpose for which we are gathered here today. And as for the mainstream media, back in the Philippines, the situation is not much better. When I argued that there has been interference in this case at the highest level, relying not on documentation that I have invented, but on documentation given to me by the prosecution as exonerating, they say I'm making a political speech and that my defense lacks substance. And when I devote more time than the prosecution and the victims together to legal arguments and challenging the evidence, they say I'm nitpicking. Well, fortunately, we have this honourable bench which appreciates the presumption of innocence and the need to examine the evidence thoroughly in order to examine whether the prosecution has proved its case to the required standard. We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand. Let me just screen you an example from the public record, from the public version of the pre-confirmation brief, so that the whole world can appreciate it. And the same goes for the redactions applied to the identities and roles of the various criminal cooperating participants. While I found this unfair and contrary to the spirit of transparency, which is meant to govern the conduct of the proceedings at this institution, I approached my counterpart in the prosecution and complained that the nature of his redactions would mean that most of my meaningful submissions, namely the attack on the evidence substantiating the 78 deaths, would require me to go into closed session. Don't worry, I was told by the learned prosecutor. We're going to release a lesser redacted version of our charging document and confirmation brief. Wonderful, I said to myself. But what in due course did we get? A document which merely released the names of the 8 so-called co-perpetrators and which caused a storm in the Philippines. It even caused the Secretary of the Interior to state that his department had begun tracing the whereabouts of these so-called co-perpetrators. And in its lesser redacted version of the document containing the charges and pre-confirmation brief, the prosecution also released the names of certain high-profile victims which it had selected, thereby enabling it, and it alone, to talk freely in open session about certain incidents that it felt crucial to its case. From this, I submit, Your Honours, you can really appreciate the true inequality of arms facing the defence as it attempts to defend a client in the public eye, I stress in the public eye, at the International Criminal Court. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges either obliquely or in closed session, including that hotly disputed incident with the CCTV. Well, we hope that we have found a way around that by referring Your Honours to the relevant places in the evidence, and we do trust you to pick up on the problems without the benefit of our full explanations in open session, even if the remaining part of our plea was rendered rather dry. But I do assure you, the general weaknesses that we have identified pervade throughout and are so recurring that the total value of the prosecution's evidentiary matrix drops not just below the substantial grounds threshold that the prosecution must meet, but hits the very rock-hard bottom. And I will summarize these weaknesses once more for the record. Layered hearsay, conjecture, over-reliance on accomplice evidence with offers of virtual immunity at the ICC, contradicting statements between participants in a crime, absolute lack of any linkage whatsoever to Mr. Rodrigo Duterte, and the total lack of support for an alleged crime both in the documentary and forensic record. And regarding these documents, it is not enough to argue that the Duterte administration destroyed them. There is absolutely no evidence for that. It is an outrageously unsubstantiated accusation which is not alleged, and where the documentation does exist, the prosecution is quite happy to rely on it. But what is this threshold, this substantial grounds to believe threshold? Well, clearly, it is not beyond a reasonable doubt. That's the standard required for a conviction at trial. But it is considerably more than reasonable grounds to believe, which is the standard applied for the issuance of an arrest warrant. If I may, let us take the analogy introduced by Mr. Butuyan, that boat of his that set sail in order to avoid leaving his victims stranded on an island. Your Honours, this boat is the confirmation process, and its captain is this honourable bench. We are all passengers in this boat. The favourable winds in the sea and in the sails are for the prosecution, the incriminating evidence, and the sharks and the rocks in shallow waters are the exonerating evidence, the hearsay, the contradictions, and the accomplice witnesses. I ask you to consider how many sharks and rocks that we have discovered and pointed out to you through our binoculars. Would you board that boat if you knew that there were substantial grounds to believe that the boat would sink if it encountered one of the aforementioned perils? Let me define the test using more strictly legal language. The evidentiary standard applicable, namely substantial grounds to believe, is met with respect to a discrete incident when, and I quote from paragraph 38 of the Said confirmation decision, there exists concrete and tangible proof demonstrating a clear line of reasoning underpinning the specific allegations. By way of parenthesis, I should state that this quote from the Said confirmation decision recognizes the fact that each pleaded incident in a document containing the charges must be proved to the requisite standard for it to be adduced at trial. And that is what we request the Honourable Pretrial Chamber to consider. I have been asked by the many journalists who literally mobbed me outside this court building whether I have been reporting on the proceedings to the former president. And I tell them, yes, of course. That's my duty as a lawyer. I have to report to my client. It would be unethical otherwise. And they ask me, what has he to say about the case? Well, I'm going to enlighten you all a bit. For the best part of a year, we have been litigating the issue of jurisdiction and fitness. Your Honours have delivered your rulings. However, even though you found him capable of standing trial, I permit myself to tell you just a little bit about what really goes on in prison. No more than a kilometre from here. I permit myself first to tell you about his reaction to the demand of the prosecution and the victims that he appear. I won't hide the fact that I thought it best for him to appear, not out of a need to satisfy the desire of the prosecutor and the victims who desperately want him to face his accusers so that they can wave their collected finger at him despite the presumption of innocence. I did not want to disappoint his many supporters. That was my reasoning. Those mini Duterte clones, as Mr. Butuyan derisively calls them, who have been deprived of seeing their former and beloved president for more than a year. I told him that Your Honours could have rejected his request to waive the right of attendance. We even had a barong specially fitted for him so that he would not have to suffer the humiliation of being put into an out-of-size blue suit which would now dwarf his meagre physical body. The same blue suit in that dreadful photograph which still remains on the ICC website and that I would ask to be removed. But he took his decision, and as his counsel, I was obliged to respect it. And the day before yesterday, when Your Honours gave us a break, I went to that prison and I sat with him for an hour. I tried to engage him concerning the evidence, and he lost the desire to follow me within less than a minute. I offered to show him excerpts of the confirmation proceedings, a few minutes of the deputy prosecutor, a few moments of Ms. Massiter, and hoping that it might excite him a bit more, some of my own opening statement. He shook his head firmly. I implored him. I said, "Sir, look at what we are doing for you. We're doing our utmost to get you out of here." But once again, he politely declined. And I asked him why. I said to him, "Sir, don't you understand? They accuse you of murder. They say that you murdered thousands when you were the mayor and when you were ruling your country." And then he repeated the question that he has always asked me for a year or more. "How does the prosecution say that I did this?" "Well," I replied, "I thought until Monday that it was because of those speeches of yours. But then your prosecutor told the honourable judges the other day, throw them all out. They're not necessary for the confirmation. He claims that he still has enough evidence to convict you without all the bluster. And the former president repeated the question, but how? I've never murdered anyone. And they talk about thousands. And then I tried to explain to him arcane concepts such as indirect co-perpetration. And then his eyes simply glazed over. And who can blame him? As I mentioned, it is the only highly technical means whereby the prosecution can artificially connect him to criminal activity not of his own doing. I then tell him that the people who are incriminating him are self-confessed murderers cooperating with the prosecution, whose names we can't mention in public. I tell him that in return for their dubious services and their expressions of so-called remorse, as the prosecutor puts it, they will not face trial at the ICC, probably nowhere in the world, and will be rehoused with new identities. Mr. Duterte, the ex-prosecutor, like me, can't understand the fairness of that, relying on not one, but a number of vicious criminals to convict him, when he remembers that he is supposed to be presumed innocent. I tell him the names of those criminal cooperating witnesses, because apart from us, he is the only person who is entitled to know. He tells me that he has not heard of any of them, apart from two, who he vaguely recalls from his days as mayor. Concerning one, his comment is liar, and concerning the other, scallywag. And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me. He then concluded and pronounced as follows, I was a faithful servant of the people, and that is how I wish to be remembered. I have now accepted my fate, and I realize that I could die in prison. And on that somber note, my team and I realized that there was no point in continuing. So we tried to humor him. We told him that next month he will be 81. And we reminded him of the many people who visit Duterte Street and Duterte Park, the renamed locality just outside the ICC detention center, as referred to by the many, many pilgrims who have visited The Hague to feel closeness to his presence, even if they cannot witness his actual person with their own eyes. We remind him of the mountain of cards and greetings and of the forest of flowers that he received both at the detention center and at the court's premises on his 80th birthday. So many cards, all of which were read by his family, that we had to provide 2 sacks to take them back to our office. So many bouquets of flowers that the prison had to bring a van to take them away. The flowers that reached the court premises were strategically placed around the building, and although so appealing and desirable and coveted by the staff, were avoided once the staff was told of their origin. So these flowers just rotted in the corridors until the smell forced them to be thrown away. We showed him some photographs of his family. We showed him photographs of his youngest daughter, Veronica, Kitty, who writes to him every day, so often that the letters are piling up in his room. His face starts to light up. We showed him pictures of civic events in the Philippines with Sebastian Baste and Paulo Pulong present. He laughed and told us what he remembers of their days as young men in Davao. We showed him pictures of Inday Sara greeting the enthusiastic crowds of people in the Philippines, and then finally his face beamed with pride. Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one, out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honours, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace, in his humble dwelling in Davao. And with that, Your Honours, I conclude, and I wish to thank you for your patience, and to thank the parties and the participants, and most importantly, my team, Dov Jacobs, Havnit Nikiseti, Sandrine Dosena, Davide Rancati, Alexandra Dezev Davi, Nicholas Russo, and Kaylin Chen, all of whom have worked throughout the last year for one cause alone, and that is to serve our client, Mr. Rodrigo Duterte, faithfully.
Merci beaucoup.
Judge Motok. Thank you very much, Mr. Kaufman. The chamber, my colleagues and myself, we have the duty to recall certain issues. First of all, the redactions that you have mentioned now. It was already raised by the defense, and the chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public. Secondly, you talked about the health and capacity of the suspect. As you have clarified, this issue was already addressed by the chamber, and the defense must not make submissions on that point now because it is not appropriate. The decision is already available in the public domain. I thank you very much, and with that we come to the end of the confirmation of charges hearings. I thank the parties. Did you want the floor, Mr. Prosecutor?
Yes, whenever it's convenient for you, Your Honor. Yeah, thank you, Your Honor. I don't want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero weight whatsoever in your determinations. Thank you.
Thank you, Mr. Prosecutor. You want the floor again, Mr. Kaufman?
Madam President, but I do believe that the defense has the right to respond.
Wait.
Yes, says Judge Moto.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect, obviously, for your honours, But he has his arguments, which we shan't repeat here once again. They were all set out in the waiver. That was not testimony, I assure you, Mr. Nichols.
Merci.
Judge Murdoch, thank you very much. Now the bench will withdraw to deliberate, and we will render a decision on the confirmation of hearings within 60 days in accordance with the instruments, the provisions. We will come back to this court for a hearing on Mr. Duterte's detention. Court is suspended.
Tatay digong stood with Bangsamoro.